Welcome to the Rock Center for Corporate Governance at Stanford Online. I'm Mike Callahan, Professor of the Practice and Executive Director of the Rock Center at Stanford Law School. Thank you very much for joining our session. Our format today will be a discussion between our two distinguished guests, followed by questions and answers submitted in advance by our audience. Our first guest is Chairman of the Securities and Exchange Commission, Jay Clayton. Chairman Clayton was nominated and confirmed to this position in early 2017. Prior to chairing the SEC, Chairman Clayton was a partner with Sullivan and Cromwell, where he was a member of the firm's management committee and co-head of the firm's corporate practice. Our second guest is Professor Joe Grundfest of Stanford Law School. In addition to his role at Stanford and as senior faculty of the Rock Center for Corporate Governance, Professor Grundfest is a former SEC commissioner, a member of the board of directors and chair of the audit committee at KKR, and a former board member of Oracle Corporation and the Financial Engines. I will now turn the discussion over to Professor Grundfest.
Thank you very much, Mike, and good morning, Jay. It's absolutely a pleasure to see you. It's been a bit of a while, and I'm thrilled that you've given me an opportunity to go out and get a clean shirt and put on a pair of pants and borrow a tie. It's wonderful getting together in this kind of a context.
Well, it's nice to see you too, Joe, and thanks for having me. I look forward to your questions because they're almost always topical and almost always incisive, even the ones that make me uncomfortable. So,
and I appreciate, and Jay, I particularly appreciate the almost, absolutely. So let's begin at the beginning. Very recently, on April 8th, you and Bill Hinman issued a statement that, to my knowledge, is basically unprecedented in SEC history, right? And what you basically came out and you said to the issuer community, change the way you're doing your disclosures. I want you to be more forward-looking, and I don't want you to be looking in the rearview mirror. Tell us about how the world is going to be different because of COVID. Tell us about how you're going to adapt. And if you want to summarize this release, I think you summarize it with the one word, forward. Look ahead and tell us what you see in the future. Two questions about that, Jay. First, is that, do you think, an accurate description of what you and Bill were trying to say? And second, why did you think it was necessary to come up with a statement of that sort at this time?
So, Joe, I think it is a fair characterization. Let me put it this way: we were trying to say what our investors want, and if you look at where we are as an economy today and a firm's place in the economy today, compare it to ordinary times. Okay, what you would do in Q1 is probably compare your results in Q1 to Q4 previously, and maybe Q1 from a year ago, and say, here's how we were incrementally better, here's how we were incrementally worse, here's what trends based on those two data points you can expect for the future. That's not relevant to an investor at the moment, or it's of much less relevance to an investor at the moment. What are the most relevant things to an investor? Where does your business sit today from a liquidity and operational perspective? How much different is it in Q2 than it was January 1, Q1? What's your liquidity position as a result? Are you a firm that can handle being in this position that you're in today for a lengthy period of time? Or are you a firm that if the status quo continues for a month or two, you're going to at least have to raise additional capital and maybe worse? That's what investors want to know across our public company and our private company spectrum. So let's all level set and say, okay, those are the things that people want to know, as opposed to the usual course. Also, from the be forward, we want people to know that we recognize that those estimates, descriptions, assumptions, they're not guesswork, but they're also not certainties. And they're not likely to be precise as events unfold. But people should make them. And, to put a word on it, we would not expect to hold people to well-founded and appropriately cautioned forward-looking statements. I mean, I think this is a time where the safe harbor for forward-looking statements, should really do a lot of work for our issuer community.
Well, let's try to unpack that on several different levels. I think it's entirely understandable and that investors would want to have forward-looking information because the past really here is no guide to the future. Historically, by doing quarter-on-quarter comparisons, seasonally adjusted or what have you, you can give useful information to investors. But now we're dealing with an unprecedented systemic shock, a supply shock and a demand shock coming together in a way that we've never experienced before. So history is going to be a very poor guide. But at the same time that you're asking companies to give forecasts, in effect, subject to the liability of the federal securities law, we're in an environment where it's the most difficult environment I've ever seen to make these forecasts. Companies in good faith will say, we have no idea how this is going to play out. We don't know when there's going to be a therapeutic. We don't know how these shelter-in-place orders are going to be in place. We don't know when there's going to be a vaccine. We don't know how we'll be able to operate. Will consumers come into the marketplace? Just as investors lack historic experience, so do managements. How are we going to navigate that challenge?
Well, let's be clear on what I do think people could do. I don't think people can make earnings estimates, particularly to the precisions of pennies, assuming any normalized stock price. But I do expect in most boardrooms they're having exactly the discussion you just had.
Yes.
I do think people can have a sense of their liquidity position in a broad way. I do think they can think about under various scenarios how they'll operate their business. And again, I don't expect a level of precision, but if the answer is, absent a complete de-risking of the situation, I really won't be able to operate the same way. Well, that's something, investors do want to know that. And we're also seeing a number of firms that seem to be able to operate almost as status quo. That's the kind of information that investors in our marketplace are thirsting for. It's also, in many situations, the kind of information they're supposed to get. And let me make one more point here. It's also the kind of information that you're inevitably going to be sharing with somebody. With your lenders, subject to confidentiality, fine. But once you start sharing it publicly in other places, FD and just good corporate hygiene say you ought to be sharing it broadly. And I'm not a gotcha guy. You've known me a long time. I'm also just telling people, think about that. If you're going to go have a conversation with the government about getting government loans out of the CARES Act, and you're broadly going to say how your business is doing in that situation, tell your investors.
You're going to have to be consistent. You can't tell the government when you're applying for the SBA loan that it's necessary, and then in your public disclosure say, "Oh no, we're just fine." You've got to be consistent at a minimum across all of those. Just as a side, I think it's possible to divide the economy right now in terms of publicly traded companies into three categories. You've got one set of companies that are doing just fine, and in fact, because of COVID, they're actually doing better. You've got another set of companies where it's, a little bit of this, a little bit of that, but pretty much the same kind of performance that we've seen in the past. And then you've got another whole set of companies that are very seriously impaired as a practical matter. And it seems to me that your advice from a variety of different perspectives really is perhaps most salient to the companies that are in that third tercile, that are impaired. And you're asking for them to be more forthcoming about the risks and the stresses and the conditions that this COVID crisis is imposing on them. Is that accurate and reasonable?
Well, I think they're the ones who it's much less business as usual from a disclosure standpoint, right? The way you set that up, the first group disclosure of the type that we are used to seeing, here's how much better Q1 was than Q4 2019, that kind of makes a lot of sense. And it gives you a picture of where the company is. The company in your third bucket, again, not so relevant, much more, what's my liquidity look like? How much capital do I have access to? What's my burn rate? Those types of things are much more relevant.
So, earlier on you used the phrase, guessing and guesswork, and you sort of said you're not looking for guessing or guesswork. But let me push back a little bit on that, because there's some situations in which, as a practical matter, that's all you can do. And let me go to an actual release, Netflix recent earnings release, where they use the words guesswork and guess. And let me quote from their release, and I actually think it's quite informative. They said, our internal forecasting guidance for 7.5 million global paid net additions in Q2, given the uncertainty on home confinement timing, this is mostly guesswork.
Mm-hmm.
I currently guess that Q3 of 20 and Q4 will have lower net additions than last year due to these effects. And what they're talking about is they've got more subscribers coming on board now, but what they think they're doing is they're pulling from future subscribers that they otherwise would have signed on Q3 and Q4.
Mm-hmm.
But what they're also honestly saying is, we don't know. That's
Mm-hmm.
a guess. All right, they couldn't possibly, in my view, have modeled for this stuff.
Mm-hmm.
And they can make some guesses as to, gee, we think 20% of these are really new additions that we otherwise wouldn't have received. 80%, we're pulling half of them from Q3, half of them from Q4. But, in a situation where you're totally lacking in any empirical guidance and support, you haven't gone out and been able to test and do anything in the market, isn't it entirely appropriate, and isn't it the most honest thing for the company to say, it's our guess that this is what's going on? We don't know.
Yes.
So in that context, it's entirely legitimate for companies to say, this is what we see happening, and this is our guess as to what might actually occur. Guessing here, it's the only thing we can do in some of these situations.
Yeah, but we're quibbling over words, Joe. I mean, I said I don't. I said
we're lawyers. We have to quibble over words.
No. That the precision of the lawyer is not what you want when you're trying to help people here. When I said guesswork, I would not want people to. Let's just take a subscriber business. I wouldn't want people to say, I expect it to be 100. I would want exactly the type of disclosure that you're saying, which is, it's really hard for us to estimate it. If that is in fact the case, if what you're sitting in the boardroom and saying is, folks, we did really well this quarter with subscribers. It probably has to do with some exogenous factors. I don't know how long those exogenous factors are going to continue. So it's really difficult to forecast. And if that's what you're saying in the boardroom, that's what you should be saying to your investors.
I think we're on the same page. Now, here's the question. The SEC is giving comfort that you guys aren't going to second guess. Anything that you view as reasonable is going to be just fine. You're not going to be coming in with enforcement actions on that basis. The private bar, all right, the plaintiff's bar, isn't going to be saying the same thing. They quite reasonably will be looking for situations where they're going to be able to second guess and criticize. That's what they get paid for. It's entirely reasonable that that's what they do, and there's an important policing function there. But you can certainly understand that counsel trying to figure out how to craft these disclosures won't be primarily concerned about what you, Jay Clayton, and the enforcement division are thinking, because they expect you'll be reasonable. But they're going to be worried about a bunch of plaintiffs' lawyers and how they might respond to disclosures that they might view as being overly optimistic or what have you. Any observations or advice along those lines?
Well, I think going back to my prior comments, if your public disclosures from a securities law perspective are consistent with the way you're discussing the future with the senior management team in the boardroom, and they're consistent with the way you're discussing the future with your lenders, or your vendors, you ought to be just fine.
Okay. So in other words, an honest disclosure of the uncertainties will suffice in this environment.
It should, and it should. If that's not the way the law is working, then we need to change the law. But I'm hopeful that's the way the law actually works.
Jay, I think you've just announced the topic of our next video that we'll have to follow up on some of these other legal, because there's the way the law, there's the way we would like the law to be, and there's the way that she actually is. There can sometimes be an air gap between those two things.
But Joe, honestly held, thought out beliefs about the future that are consistent with your management team, your customers, your vendors, and the securities markets. You know, if there are gaps in that as far as legal liability goes, well, then we should explore them.
Absolutely. Now, the other interesting thing is many of these questions about judgments, estimates, forecasts, and perhaps guesswork show up not only in the textual disclosures of these documents, but they're embedded and they're essential to many of the accounting decisions that are made that are not typically viewed as forward-looking statements in every context by every person. So, for example, valuation decisions, all right? When you're trying to value level 2 and level 3 assets, you've got to make some forecasts. You've got to have some assumptions. When you're making a determination as to going concern, all right? Are you going to get a going concern letter from your auditors? What about the impairment of assets? How do you handle accruals? All of these are issues where the company, together with the auditors, wind up having to make judgments, and these judgments are particularly challenging in this environment. What kind of advice and suggestions would you give as part of that accounting process where, again, it's inherently forward-looking, even though many people don't perceive it that way?
Well, you're right to characterize it that way. And again, going back to what we'll call the ordinary paradigm, those types of judgments as a routine matter are fairly easy to make because it's easy to project from past performance. Here it's very difficult. I think you just have to start with the recognition that for the many of the companies, if you put it in your 3 buckets 2 and 3, it is going to be difficult. And again, having those kinds of candid conversations with your audit committee and your auditors, and do you expect your business? Let me put it this way. I think I'm going to be more definitive than typically somebody in my position would be. But if what you're hearing is that you would expect the economy to return to some level of normalcy by year end, and that seems to be a consensus view, factoring that in to the way you evaluate impairments and the like seems entirely reasonable to me, Joe.
All right. So in effect, what you're saying, and I think this is very important guidance for a large number of issuers, is that if you assume that we're back to a normal state by December 31, and that's the assumption on which you're looking at a wide variety of different assumptions, and you just put that out there, and you say, this is guiding our determination on valuations, on impairment, on a whole bunch of different forecasts, that should be fine in that context.
Yeah, provided, let me put a proviso around this, provided that for your sector and your company, you're largely in line with the consensus as to where the economy would be. Now, there may be companies or sectors where that's not a reasonable assumption, but I'm giving you for the let's just say, the Acme, as in Looney Tunes company, right? It's
all
like
right.
For the ordinary.
Jay, I would suggest you find, because you remember what Acme and Looney Tunes does. It blows up, it explodes. Yep. So I would suggest we find another analogy.
Oh, no, I always go back to things I learned in grade school. They've served me well, Joe.
I think they've served me well too. But I'm afraid that the Acme references to Roadrunner cartoons, and that was the exploding dynamite.
Yeah.
But I think many registrants and their counsels will take what you just said very much to heart and say, well, all right, absent circumstances that are unique to our company or our sector, a starting place for analysis might be the assumption we're back to normal by the end of this year, even though a large number of highly informed experts say, no, that's far too optimistic a view.
Look, you have to pick a view or a range of views, right, Joe?
Yes,
you know,
absolutely.
So together with your auditors and your and your board of directors making reasonable judgments, that's what we're supposed to do, because the alternative to making a reasonable consensus informed based judgment is paralysis.
And assuming that we'll be back to normal is in the zone of reasonableness with regard to these judgments where that assumption of normality kicks in January 1, 2021.
Yeah, and we all want to look. We all want certainty in our lives. That assumption, again, I'm positing it may be reasonable today. A month from now, it may not be reasonable. We may know more.
Mm-hmm.
We may know more one direction or another.
It's the moving target.
We are on a course where we're going to learn more day by day, and you're going to have to course correct day by day. There's nobody who has charted the course for the next 9 months who's going to be, accurate with a degree of precision that the textbooks would like.
Absolutely understood. Jay, you've been extraordinarily gracious and generous with your time. We've got some questions from the audience. Let me turn it over to Mike Callahan, who'll join us with those questions. Mike, to you.
Thank you very much. First question we have is that the last several years have witnessed a significant decline in the number of companies reporting new FCPA-related investigations being conducted by the SEC. Does this decline reflect an actual decline in the number of FCPA investigations that the SEC is actively conducting? And if so, has there been a policy change with respect to the FCPA? And if not, what are some possible reasons that public companies are reporting fewer FCPA-related investigations?
Well, that's not one question. That's like 5. But so let me take it from the top. Absolutely no policy change in how we approach the FCPA here. And in fact, I don't think we've had we had a little bit of a change in personnel, but we have people who are very experienced in this area and very good at it. I think what you referred to was a change in the reported number of cases looking at public filings. We don't comment on outstanding investigations, but I do know that I think in the last, I think last year we had almost 20, maybe 18 or 19 FCPA cases. In the previous few years we had over a dozen. I don't expect any change in the number of cases, and I don't have a different perspective on it. You also want to know that these matters, unfortunately, and this is very unfortunate, they generally take a long time to gestate because the evidence is outside the U.S. There's lots of things you have to go through, and I'll just take this opportunity to say one more time, I am not going to change the way we look at it. I'm not going to change the zeal with which we pursue these, but it is unendingly frustrating that for 25 years I've been hearing from other jurisdictions, just give us a little more time. We'll catch up and start doing this with you.
Understood. Thank you. Our second question is, as corporate compliance officers increasingly reinforce the importance of ethical behavior and compliance and speaking up during COVID-19, can you share whether and how the SEC's priorities may have shifted in light of COVID-19? And in particular, if employees have concerns about a company's practices or their response to the COVID crisis, can they come to the agency if they also think their company's disclosures don't fairly reflect their behavior?
Yes, to the second question. Yes, we are open for business for all participants in the marketplace. Our tips, complaints, referrals program, I'm very proud of it. I think we deal with tips, complaints, and referrals on the outside within 72 hours. If somebody is seeing something that makes them uncomfortable from a disclosure point of view, or any other point of view that would impact the securities laws, come to us. The sooner the better.
Yeah, let me reinforce the chairman's point. The SEC, just within the last several weeks, has given out many millions of dollars in whistleblower awards, basically designed to incentivize people to come to the agency and to disclose problems, any violation of the federal securities laws, whether it's a publicly traded or a privately held firm. If it leads to recovery, the SEC, under appropriate circumstances, will pay whistleblowers, and it's a very valuable source of information for the agency.
Joe, thank you for that plug for our whistleblower program.
It's
because
it's great.
I'm very proud of what we've done. We've increased the pace at which we bring cases, and we're increasing the pace at which we go through whistleblower awards and award them, so that when somebody comes to us and identifies wrongdoing, they get that award much faster, and that's really important, because if you've decided to have that kind of program and you want to incentivize people, telling them that your incentive is coming 6 years from now is a lot different from telling them that their incentive is coming 2.5 years from now.
No, that's exactly right. And just as an outsider observing the pace at which you're moving, obviously we don't have information as to when the claims are initially submitted, when the cases are resolved and the like, but you can just infer that the cadence is picking up and that the agency is doing exactly what you just described. And it will have that effect on whistleblowers, no doubt. Congratulations.
I think we have time for one more question, if you do, Chairman Clayton,
Sure.
Related to shareholder activism.
For Grundfest, I always run over.
I'm trying to end on time. Shareholder activism. Is the commission concerned that some shareholder activists are behaving opportunistically in the age of COVID, taking advantage of depressed stock prices to generate short-term gains for themselves? And if the commission is concerned about potential abuse in this space, what would be the agency's approach to address it?
You know, I think, let me put it this way. Hopefully at this moment, that the question of unfair advantage, _unfair, is a hypothetical. I'm not aware of situations where we're seeing people take advantage unfairly of inappropriate price discovery. But you know, look, that's a very nuanced question, and if there are people who feel that way, they should contact us. And if they think that this, what I would say is time of great uncertainty, has resulted in a situation where the people I come to work worried about, long-term investors, are going to somehow lose out because companies are going to be taken private at a low price without appropriate governance, let us know.
Thank you very much. I want to take this time to thank you, Chairman Clayton and Professor.
Can I check something? Hey, Joe, did I get that right?
Close enough. Close enough, Jay. Close enough for commission work.
You know, you got to check with your critics.
Yeah, absolutely. That's why I keep calling you, Jay.
Well, I want to thank you, Chairman Clayton and Professor Grundfest, for joining us today to share your insights and perspectives. Incredibly valuable for our audience here at the Rock Center. And I want to thank our audience for joining us as well. And have a nice day.